So for Uber, it's not just rain, it's thunderstorms, hail. I mean, it never ends. It just comes down one lawsuit after the other. I mean, they must have an army of attorneys, right? And then those law firms like Gibson Dunn, I mean, they are just cashing in through all the quagmires, all the legal problems that Uber has. So again, Uber and Lyft face new lawsuit from California Labor Commissioner. Thousands and thousands of drivers have been filing complaints with the California Labor Commissioner, and they're just probably so sick and tired of the abuse. So they went ahead. Uber and Lyft are both facing another lawsuit from the Office of the California Labor Commissioner alleging wage theft. Remember, they were sued by the state. They were sued by Javier Becerra, the Attorney General. Now this one, they just got sued yesterday by Anthony Lewandowski for $4 billion, one of their execs that's going to jail. Doesn't stop. So filed today, the suit argues both Uber and Lyft are misclassifying their drivers as independent contractors. We know that, and aim to enforce the labor practices set for AB5. There's still too many people out there that believe that they are true independent contractors, right? Under the definition of independent contractor, you are currently not an independent contractor, because if you are an independent contractor, you can decide where you want to drive, when you want to drive, with which company you want to drive. You get to set the rate. So many people just have a false understanding of what a true independent contractor is. The Uber and Lyft business model rests on the misclassification of drivers as independent contractors. California Labor Commissioner Lilia Garcia-Broa said in a statement, this leaves workers without protections such as paid sick leave and reimbursement of drivers' expenses, as well as overtime and minimum wages. We don't get any of that. So hopefully, if you haven't already filed with a law firm, you get, under this protection, you get a lot of money coming your way. The goals of the separate suits are to recover the money that is allegedly owed to these drivers by classifying drivers as independent contractors rather than employees. Both Uber and Lyft have not been required to pay minimum wage, overtime compensation, nor have they been required to offer paid breaks or reimburse drivers for the costs of driving. AB5, which went into law earlier this year, outlines what type of worker can and cannot be classified as an independent contractor. The law codifies the ruling established in the Dynamax Operations West Incorporated versus Superior Court of Los Angeles. In that case, the court applied the ABC test and decided Dynamax wrongfully classified its workers as independent contractors. According to the ABC test, in order for a hiring entity to legally classify a worker as an independent contractor, it must prove the worker is free from the control and direction of the hiring entity, and that's not the case. Performs work outside the scope of the entity's business, and that's not the case, and is regularly engaged in work of some independently established trade or other similar business. That's not the case. These suits are seeking for the court to order Uber and Lyft to classify their drivers as employees and provide them with all the protections that come with being a W-2 employee. For years, Uber and Lyft have been stealing wages and exploiting every legal loophole they can to avoid paying drivers what they deserve. Transport Workers Union President John Samuelson said in a statement, "It was shameful before, and it's even more shameful now, during the middle of a pandemic, that we have allowed wealthy companies to get away with this. This lawsuit is an essential part of holding these companies accountable and protecting drivers' rights." These new lawsuits come just months before Californians are set to vote on Proposition 22, a ballot measure backed by Uber, Lyft, and others. The ballot measure looks to implement an earnings guarantee of at least 120% of minimum wage while on the job, 30 cents per mile for expenses, a healthcare stipend, occupational accident insurance for the online job injuries, protection against discrimination and sexual harassment, and automobile accident and liability insurance. Most notably, however, it would keep drivers classified as independent contractors. As the lawsuit clearly demonstrates, Sacramento politicians are more interested in the wishes of their special interest donors than the will of the vast majority of drivers, and are intent on stripping drivers of the freedom to choose independent work. The Yes on 22 campaign said in a statement. Well, I vote no on 22, and I have 150 reasons why. They say this coordinated effort by all levels of government to run a politically motivated campaign will hurt the state at the worst possible time. Who's hurting the drivers at the worst possible time? Not getting hazard pay, not getting pandemic assistance, etc., are the gig economy companies. So they can't, the fingers that are pointing that way are pointing directly back at them. And hopefully the public doesn't get fooled by their attempt to muddy the waters, right? So we shall see where that goes. Again, thank you, California Labor Commissioner, for applying more pressure. I believe this is a good thing. Why is this a good thing? Because I truly don't think we're going to be classified as employees, and I don't think we're going to remain independent contractors as per them. I think it's going to be a new gig hybrid law that will come into effect, and the more you mount the chips against them, the more they have to cut a deal. So it's going to be like this, meeting somewhere in the middle and hashing out a completely new law. That has always been my opinion from day one, and I've been reporting on this already for years. So we shall see where these cases go to. It's going to be interesting. Your comments, please. Thank you so much for watching. I appreciate you, and please stay safe out there.